So the real debate now is whether, well, they did it and we've been living with it for 50 years. And so, you can't really pull that rug out from under women, is what the liberals say. And the other side saying bad law is bad law and it should be overruled when you're given the chance. Is that basically the nut of it?
That's exactly it. And, they've changed over the last decades, the argument for why abortion should remain not just legal at the federal level effectively, but it should be somehow enshrined as a constitutional right when the Constitution says nothing about abortion. It doesn't even say anything about the privacy that they claim should be the justification for abortion, at least one of their initial claims. What it does say under the 14th Amendment is that there should be equal protection for all persons under the law and that the state should not deprive anyone of their life without due process. And that is actually a case against abortion, for why states have an interest in protecting innocent human life. And also, you shouldn't be depriving the preborn of their lives without due process, and you should be giving them equal protection. So, yeah, there's a lot of bad case law, decades of bad case law. And now finally, there's a chance to rectify that. And the court may actually do that because you have six, you could call them more conservative or call them more originalist, but six justices who have indicated, even by taking on this case, even by agreeing to hear abortion, the 15-week abortion ban from Mississippi, have indicated that I think it's I dare say likely chance that they're going to uphold this law. And that's going to deal big damage to Roe v. Wade and other abortion case law.
Yeah, explain that, because Mississippi did something we've seen many states do many times. And, the Supreme Court always denies the appeals on these cases because what normally happens?
Normally what happens is these laws get struck down. So basically any law at the state level that tries to ban abortions on babies before around 21 weeks, which is this moving line of viability. So Casey v. Planned Parenthood was this 1992 case that basically said it was another kind of explainer of Roe and trying to create more justification after Roe was so tenuous in how it even argued for abortion. But Casey v. Planned Parenthood basically says that if you're a state, you have an interest in protecting fetal life before viability or after viability, because the baby is old enough. So all of a sudden the baby has enough, there's enough reason to protect that baby. But before this arbitrary line of when the baby can survive outside the womb, then the state can't ban abortions. And so what has happened over the last 2 decades, and particularly in the last 2 to 3 years, there's been this wave of pro-life legislation attempting to protect children before this, arbitrary line of viability. If you're a baby at 21 weeks deserving of legal protection, why not 20 weeks? Why not 19 weeks? Why not 18 weeks? Really, there's no reason why the baby shouldn't deserve protection and not be killed at an earlier age. So Mississippi does 15 weeks. One of the reasons I think they chose that is because most Western countries, most of our allies, most of Europe bans abortion after the first trimester. So they're kind of using that very rough trimester framework to say, okay, let's try banning at 15 weeks. So after that, right after the first trimester. And this is, of course, challenged. But this time, the Supreme Court agrees to hear the case. And this time, you've got 6 justices potentially on the Supreme Court who might uphold this law, when in past courts, of course, we've had not enough votes to uphold a pro-life law. So that's why this is a huge deal. And many people are saying this may be the end of Roe v. Wade, at minimum, the end of Roe v. Wade and its power to prohibit states from doing basic legal protections. I mean, you can argue a states' rights argument for why states should have, their people, their democratically elected leaders should be able to pass pro-life protections. But, my argument here is, and I think the ultimate pro-life argument is, nobody has the right, whether you're a democratically elected legislature or you're the Supreme Court, of the United States, nobody has the right to say that because you are pre-viability as a human being, because you're only, 6 weeks old with a beating heart, the very early beginning of human life, you don't have legal protections. I mean, we don't have the right to draw arbitrary lines in the sand and say, you're human now, worthy of life, and now just days earlier, you're not a human. That's illogical, it's immoral, it's unjust. And that's the ultimate pro-life case, to say, if you're human, you have human rights. Human rights are universal. If you're human, you have human rights.
Of Justice Kavanaugh's comment yesterday on the bench, because he was getting to that, the fact that if you have a mother that wants to abort her baby, there is an inherent conflict in the rights of the woman and the baby. I mean, it's so uncomfortable to even think about, really. It's like mother and child are divided when it comes to what they want and what's best for them. You know what I mean? Like, there's an assumption that the child belongs, it has a right to live. It has a right to be here. And the mother wants it not to be. And he kind of, let's listen to the Justice Kavanaugh side. It's soundbite 12. I think he gets right to the heart of it.
In your brief, you say that the existing framework accommodates, that's your word, both the interest of the pregnant woman and the interest of the fetus. And the problem, I think the other side would say, and the reason this issue is hard, is that you can't accommodate both interests. You have to pick. That's the fundamental problem. And one interest has to prevail over the other at any given point in time. When you have those two interests at stake, and both are important, as you acknowledge, why should this court be the arbiter rather than Congress, the state legislatures, state Supreme Courts, the people?
I mean, that I've never heard a justice dealing with abortion rights get right to the heart of it. He's raising the point you were raising, which is, you're talking about that. Shouldn't the people's representatives be in charge of the decision of weighing those two competing interests? Why should 9 judges in robes have that power?
Right. And that's Mississippi's case. I mean, that's what their Solicitor General was arguing. Give us the right to protect children in our state. I mean, our people want this. Why can't we do this? But, it's interesting. Justice Kavanaugh's comment about, these rights are in conflict and someone's rights are going to have to prevail. And why does he's basically saying, why is it after viability, all of a sudden the child gets to live and their rights prevail, but before viability, they don't? I mean, it's going to that arbitrary standard, which was drawn in KCV Planned Parenthood. And I would say, listen, I disagree as a woman and a mother myself, this framework of saying that a woman's interest is to have an abortion. And I think that's one of the greatest lies that we have just bought as a society, even to the degree where the pro-abortion attorneys yesterday were arguing that we need abortion as backup contraception. I mean, they said that straight up. They said that 10% of women who are 10% of contraception fails. They even admitted that. And so we need abortion as backup contraception. And so this framework that we're operating in now legally, which says that, the child has as an interest, a right to live, but this woman has the right to kill the child because they're dependent on her. I don't think that's actually in a woman's interest. So I would go a step further and say, it's not in our interest as women to accept the paradigm that we need abortion to be empowered. And if we design our society where we need this trap door of abortion to get out of tough situations, or we basically live a sexual ethic or lack a sexual ethic, and so we put sexual pleasure on this pedestal and say we have a right to sexual pleasure without consequences. Therefore, we need abortion as backup birth control. I don't think that's a healthy society. So I think there are actually bigger ramifications for this whole legal discussion, bigger questions we need to be asking ourselves, both as a society and for our public policy.
I mean, that's a moral question, but it fits in because they necessarily are dealing to some extent with morality inside that courtroom. The other side, of course, says that women need to be able to make their own choices about how their life is going to go. And if they become pregnant, by accident, unintentionally, that they should have the right to not be forced to carry a child to term, to raise a child. And I thought that it was like the big question was, as I understood it yesterday, Thomas, Alito, and Gorsuch seemed very much in the camp of Roe is going away. That's the big ruling, because they could rule Roe versus Wade is no longer good law. We are no longer recognizing a fundamental right to abortion. They could rule, we're not doing that. We're not reversing Roe, but we're going to say this 15-week ban is fine, even though it's pre-viability, which would open the door for all states to move the line much earlier in a woman's pregnancy, or they could uphold the Mississippi law. I agree. They're not going to uphold the Mississippi law. They wouldn't have taken the case. The lower court struck down the law. If they agreed with that, they wouldn't have taken the case. So it's going to be one or two.